Many assume a will controls every asset they own, or that a trust is a simple tax avoidance loophole. Both beliefs are dangerous myths. Courts prioritize legal structure over personal intent. They aren't looking for what feels fair after you're gone. They're looking at how you labeled the accounts. The legal system operates on a rigid, mechanical logic, categorizing every asset you own into specific legal buckets. For 90% of families, estate planning comes down to selecting the right vessel for assets, a will or a revocable living trust. Frame the choice as a calculation of timing. You decide if you'd rather manage the administrative friction now while you're healthy, or leave it for your family to navigate on the back end. Selecting the wrong structure leaves grieving families trapped in a court-mandated legal freeze, unable to access funds to pay bills or manage property for months. Misunderstanding these structures risks misdirecting your assets while guaranteeing trauma and legal limbo for your loved ones. Before you choose between a will and a trust, you have to understand the legal trump cards that dictate how assets actually move. At the top is the contract. Naming a beneficiary on a 401k creates a binding agreement overruling your will every time. Second is title. Joint ownership automatically transfers full control to the survivor. The bottom tier is probate, the catch-all bucket for any remaining assets. Your entire estate plan depends on which tier your money sits in, because the law follows the paperwork, not your promises. A will has one specific job. It provides instructions for that bottom probate tier. The reality of a will follows a clear formula: death plus probate plus public. A will remains dormant while you are alive. It has no legal power to move assets or grant authority until you pass away. Because a will is written specifically for a judge to read, using one guarantees your estate will go through the probate court process. Court involvement turns your family's financial details and asset distributions into a matter of public record. A will also offers no protection during a medical crisis. If you become incapacitated, a will provides no mechanism for a loved one to step in and manage your affairs. A will is an efficient, low-cost way to plan for simple distribution, but it defers the heavy lifting, the time, costs, and scrutiny to your grieving family. A revocable living trust is a proactive management vessel that separates who manages an asset from who benefits from it. A trust follows a different formula: life plus incapacity plus privacy. However, a trust is only effective if you fund it. You must physically retitle your bank accounts and real estate into the trust's name for it to work. Properly funded assets bypass the probate court entirely, allowing for a fast and completely private transfer of wealth. The most significant benefit occurs during a health crisis. A successor trustee immediately takes over your finances without needing court permission if you become incapacitated. Note that a revocable trust is not a tax strategy. Because you retain full control, the IRS still treats these assets as part of your personal estate. Choosing a trust provides privacy and seamless continuity, provided you're willing to handle the upfront costs and administrative maintenance. To decide which tool fits your life, plot your family's specific complexity against your total asset value. The simple route applies to modest estates with straightforward family dynamics, where most wealth is tied up in 401ks or life insurance. For these profiles, a well-drafted will and updated beneficiary forms are usually sufficient to handle the remaining probate assets. The complex route involves second marriages, stepchildren, or owning real estate in multiple states. A trust manages these complications by avoiding multi-state probate and allowing you to stagger distributions to your heirs based on age. You are essentially choosing when to pay the price: do the legal work now to simplify things, or leave the court system to sort it out later. Aligning your tools with your actual financial reality prevents overpaying for complexity or underprotecting your family. One universal exception remains. If you have minor children, a will is a legal requirement. Trusts and beneficiary forms lack the authority to name a guardian. Only a will allows you to nominate who should raise your children in your absence. Parents should view these as complementary tools: a trust to oversee the inheritance and a will to protect the children. The goal of estate planning is to engineer your asset structure today, removing the burden of chaos from the people you love tomorrow.